Welcome to the Ask Junior Daily Judgment Podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Today we're discussing a fascinating judgment from the Supreme Court about driving licenses, something that affects millions of Indians who drive for a living. The case is Bajaj Allianz General Insurance Corporation Limited versus Rambha Devi.
And what makes this case particularly interesting, Priya, is that it resolves a long-standing confusion about whether someone with a light motor vehicle LMV license can legally drive a transport vehicle. Let's start with some context for our listeners. What exactly led to this case?
Well, Arjun, this case has quite a history. It all started with a series of conflicting judgments over the years about whether drivers with LMV licenses could operate transport vehicles weighing less than 7,500 kilograms. Insurance companies would often deny accident claims involving such vehicles, arguing that the drivers needed a separate transport vehicle endorsement on their licenses.
And this created quite a predicament for many drivers, didn't it? I mean, think about auto rickshaw drivers, taxi drivers, and delivery vehicle operators. Their very livelihoods were at stake.
Exactly. The court actually uses a hypothetical character named Shri throughout the judgment to illustrate the real-world impact on drivers. But before we dive deeper, let's explain some key terms for our listeners. Arjun, could you break down what we mean by light motor vehicle and transport vehicle?
Of course. Under Section 221 of the Motor Vehicles Act, a light motor vehicle is defined as any vehicle, including transport vehicles, that doesn't exceed 7,500 kilograms in gross weight. A transport vehicle defined under Section 247 includes public service vehicles, goods carriers, educational institution buses, and private service vehicles.
And this is where it gets interesting. The insurance companies argued that even if a transport vehicle weighs less than 7,500 kilograms, drivers still need a separate transport vehicle endorsement on their license. They pointed to various provisions in the Motor Vehicles Act that seem to create distinct requirements for transport vehicles.
Right? Like Section 4.2, which sets a minimum age of 20 years for driving transport vehicles compared to 18 years for regular vehicles. Or Section 7.1, which requires 1 year of LMV license experience before getting a transport vehicle learner's license.
The case ultimately reached a 5-judge Constitution bench because of these apparent contradictions in the law. The key question was, should we interpret these provisions as creating completely separate licensing requirements, or is there a way to harmonize them?
And this is where the court made a really interesting analysis. They used what's called the principle of harmonious construction, essentially trying to interpret the law in a way that gives effect to all provisions without making any of them redundant.
Exactly. The court came up with what I think is a very practical solution. They said that when the Act talks about additional requirements for transport vehicles, these requirements apply only to medium and heavy vehicles weighing more than 7,500 kilograms.
So in other words, if you have an LMV license, you can drive any vehicle, transport or non-transport, as long as it's under 7,500 killing.
That's correct. The court found that this interpretation makes the most sense because it preserves the strict definition of light motor vehicle in Section 221, which explicitly includes transport vehicles, while also giving meaning to the additional requirements for heavier transport vehicles.
You know what I found particularly interesting? The court's discussion of road safety concerns. The insurance companies argued that allowing LMV license holders to drive transport vehicles would endanger public safety.
Yes, but the court made a really important point there. They noted that no empirical evidence was presented to show that accidents increased because of LMV license holders driving light transport vehicles. They emphasized that road safety depends on many factors, like careful driving, following traffic rules, and avoiding distractions, regardless of whether the vehicle is classified as transport or non-transport.
The court also addressed the practical implications of the alternative interpretation, didn't they? Like that bizarre situation where someone getting tested on an auto rickshaw could end up legally qualified to drive a heavy multi-axle truck just because both fall under the broad category of transport vehicle.
Absolutely. And they used another great example about training requirements. If every transport vehicle required the extensive syllabus designed for heavy vehicles, including things like hill driving and cross-country practice, it would be completely impractical for auto rickshaw drivers.
Let's talk about the implications of this judgment. What does it mean for drivers and insurance companies going forward?
Well, it provides much-needed clarity. Insurance companies can no longer deny claims merely because an LMV license holder was driving a transport vehicle weighing less than 7,500 kilograms. This protects the livelihoods of countless drivers who operate such vehicles.
The judgment also upholds the 2017 Mukund Dewangan decision, right? Although it adds some additional reasoning?
Yes, and that's significant because the system has been operating under Mukund Dewangan for about 6 years now. The court was careful not to disturb that settled position, especially given its impact on drivers' livelihoods.
One interesting aspect we haven't discussed is how the court dealt with the 1994 amendment that introduced transport vehicle as a separate class in Section 10. Could you explain that?
Sure. The court found that the 1994 amendment, which merged 4 categories, medium goods, medium passenger, heavy goods, and heavy passenger vehicles, into a single transport vehicle category, was meant to simplify the licensing scheme for larger vehicles. It wasn't intended to create a new requirement for light transport vehicles.
The court also made some interesting observations about the role of the legislature, didn't they?
Yes, they noted that while the current interpretation works, the legislature might want to consider a more comprehensive amendment to address various concerns. In fact, the Attorney General informed the court that some amendments are already being considered.
Before we wrap up, should we mention the specific cases that were overruled?
Absolutely. The court overruled 3 significant decisions: Prabhu Lal, Roshamben Rahimansha Fakir, and Angad Kol, which had held that a separate endorsement was necessary for transport vehicles. They also partially overruled Anapa Irapa Nasaria regarding its interpretation of the post-1994 amendment position.
And that brings us to the end of today's analysis. We hope our listeners found this breakdown helpful in understanding this significant judgment about driving licenses.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
And don't forget to tune in tomorrow. Until then, this is Arjun Gupta.
And Priya Sharma signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.